This is one that on about the 37th or 38th day went to a special subcommittee of this, and this is what we have before us is not the one that was originally presented by Senator Hill. There was talk about insurance. We use the word elemosity a lot, and this was one that was passed by this committee and then by the committee by the subcommittee and then by the committee as a whole that dealt with this. And basically what it is where somebody that is no more than a financial supporter of a charitable event is not going to be held liable for any kind of damages. And if there is some sort of culpability there, then the standard would be either willful, wanton, or gross negligence. But the purpose is if there's a road race in Wachovia or some other bank does nothing more than sponsor and they're allowed to use their name, then they cannot be held liable or into a lawsuit. I think the question that came up last year was that not the case in Georgia anyway? But this is just kind of out of abundance of caution and also allows for them maybe to be sued and to spend a considerable amount of money to get out of a lawsuit. It just makes it clear on its very face that a financial supporter is not liable as being an entrepreneur of not putting on some kind of charitable event. And I think it left both committees real well, passed with good margin. I don't remember if they were what the count was. 10 months erodes a little bit of memory. But of all these things, nothing has changed since last March 31st, and the Senate is in full accord with the changes that we made, and their author in particular, Senator Judson Hill.
Thank you, Representative Tumlin. I appreciate that. Are there any questions from members of the committee? Representative Snell.
Thank you, Mr. Chairman. I don't know who this question is to, either you, Mr. Chairman, as a learning attorney or Mr. Tumlin, but it seems to me that on page 1, lines 20 through 23, it appears to me that if somebody writes a check for somebody to buy Coca-Colas, they are not liable. But if somebody wants to go buy the Coca-Colas and bring them and visit them, they are liable. What's the thinking behind that?
Mr. Tumlin is much more learned than I am. You want to tackle that one? Or?
Right. I think where the bill was headed with that is, they give the money, just generally, and then the promoter of the event, makes management type decision and buys Coca-Cola. But if somebody like Coca-Cola prevented Coke, then they basically, if they get Coca-Cola, then what they're doing is giving their product, and it wouldn't extend to their normal product liability. But the fact that they give money, and it's just a management decision to spend that money in certain ways, then I think you just get financial aid and not participate in any management decision.
Go ahead.
And I think your point's well taken. And I think when you read it, once you step over the line and become part of the management decision, if you say, I will give you $10,000 and you have to buy certain coats from a certain grocery store or use certain materials for the other, then you've actually become left just purely a financial supporter to being part of the management team, and you would not have that protection under this particular bill.
And let me attempt to, if I may, expand upon that a little bit. Let me give you an example. If Wachovia Bank, for example, gives $10,000 to the Atlanta Peachtree Road Race for them to put that road race on, and something were to go wrong at the road race, you could sue the road race, but you couldn't sue Wachovia just because they gave money to help out an event that we all think is great. However, if Wachovia, I'm trying to think, maybe my example doesn't quite fit, provided their location out in the country for the road race, whenever you invite somebody onto your property, you're going to be held to a certain level of care that you're not inviting them to a pit of quicksand, so to speak, or a property with something obviously dangerous. So the idea is that we want to protect people who simply make a money donation and then go away and have nothing to do with the event other than trying to help out some charitable event or some good event like the road race. However, we want to draw a distinction between that and someone who takes a higher responsibility, such as inviting them onto their property. Then we all have a certain level of responsibility that we owe to people. That would be an example, I think, of what you're getting at. Does that make sense?
Mr. Chairman,
painting to be sold for.
be sold at auction.
Gotcha.
The money goes to the thing. It appears to me this wording would say that if you gave the painting and something went wrong, you'd be liable, but if you wrote the check for the painting, you wouldn't be. I don't understand why we don't extend it. I'm for what you're trying to do, but I'd like to extend it further and say that, you know, if you buy and you build coats or you provide paintings or whatever it is, why should you be liable under that?
Let me give you the example of that. Let's say you were providing, for example, let me see if I can think of something here. You were providing the boats for a ski tournament at Lake Lanier. Okay, Wachovia just didn't give $10,000, but they actually, Wachovia's got a place on Lake Lanier, and they have boats, and they use them for skiing purposes. Well, they didn't maintain those boats, and they knew that one of the boats had a problem with the gas line before. There was a memo in the file saying they should have fixed that gas line. They did not. The boat blows up and somebody gets terribly burned. Then Wachovia probably should be held responsible for the fact that they knew that that boat was in bad shape and that it had a fire hazard, and they did nothing about it. So how are you going to distinguish in this writing between donating a boat for use or donating a picture for use, if you for sale, for example? I think you're exactly right. If all they did was give a painting and it was auctioned off for charity, I would say, yeah, in that example, it probably makes sense that they shouldn't be held liable because they just gave a painting, and what damage can a painting do? However, the trouble we're going to have in wordsmithing this is to, without drawing a list 3 or 4 pages long, try to enumerate every possible thing that you could give that you can't be sued for, that you didn't give that you could be sued for. Does that make any sense? We're trying to provide some protection where none exists now. And I think you're exactly right. We can all think of instances where we could think of something that they donated and we wouldn't want them to be sued for that. However, we could also think of many instances when they did donate something that we would want them to be responsible for. And I would think that we would have trouble probably trying to distinguish between the two in a piece of legislation. We're going to provide them more protection than they already have. We will not provide them the most protection we would like to if we could sit on individual cases. That's a situation where you'd have to rely on the judge and the jury to say that we're just not going to hold somebody responsible for donating a painting. Your point is well taken, but I think that being able to put it into a bill would probably be difficult, if that makes sense.
Can I, just to address what you're saying, I think also you have to read, financial could be cash and it could be in-kind contribution. But I think the important thing there, when you read this, is in conjunction with lines 15 and 16, is that, financial is one place, but if you get in, as it says in 15, in any way involved in the management, organization, planning, or execution. I think it's when you step over the line from turning the money into how it relates to item 16, those things that are enumerated.
Any other questions of Representative Tumlin? Yes, ma'am. Press your light there so I can turn your mic on. Gotcha.
I know in my home district we have a lot of churches using bank parking lots for car washes. Now, so this and the bank, if they just use the parking lot and something happens, the bank is automatically can be sued for if someone's hurt at the car wash, they can be held responsible.
Let me respond to that this way, if you don't mind, Representative Tumlin. I see where she's going. Let's talk about why you can be sued, first of all, because there's a difference between being sued and being successful. I can really, under the law, sue Representative Chanel because I don't like the color tie he's got on. Now, I'm not gonna get very far in the judge. You don't like it either, okay? I was just kidding with you. You won't get very far, and the judge will throw you out and probably award attorney's fees to the side you're harassing for such a suit. So nothing's going to stop anybody from being sued. However, being successful is the next question you have. Here's the difference there. Yes, let's say that the bank donates their parking lot for a car wash. Now, if they do nothing wrong other than donate, and there's nothing wrong with that parking lot, we would have to hope that when that case goes before a judge and jury, they wouldn't hold the bank responsible. However, what we do want the bank to be held responsible for is that they knew that there was a sinkhole in that parking lot that was already slumped some. They had somebody go into there, and they knew that it had been washed out underneath, and it was just a matter of time for that asphalt fell through. And you had a bunch of kids finally get on top of it, and sure enough, it fell through, and some of them were hurt bad. We probably would want the bank to be held responsible for that. And it goes back to the same analogy I was trying to give Representative Chanel. There are instances where we certainly wouldn't want them to be sued, and there are instances where we probably would agree that they should be sued for what they did. And trying to, on a piece of paper, and a law legislate that at this given time would probably be very difficult. I'm not saying impossible, and you might be able to come up with some legislation to do that, but whenever you have to go through legislation where you make a list like that, you always run into problems. Does that respond to you?
That does very well.
Yeah.
Thank you.
Any other questions of Representative Tumlin or anything that we could try to answer for you about concerns about the bill? Is there anybody here who would like to speak? Oh, we do have one now here. Representative Cooper.
I mean, wouldn't it be possible on line 13 to cover part of it if you only financial and put after financial either in cash or in kind? I mean, would that be?
I think what you would be doing in that case, and Representative Tumlin, correct me if I'm wrong, you would probably be narrowing the scope of the protection rather than increasing it. In other words, it's financial right now could possibly be interpreted as something, you know, more than just cash or in kind. I mean, if you gave, I don't know, if somebody gave donated securities to a charitable event and they turn around and sold those, I don't know if that would be cash or in kind, but it would be a financial contribution. So there might be possible ways where you could describe a donation which was not cash or in kind, but it was still financial. Does that make sense?
Well,
I think your attempt was to improve the scope of the protection. My fear is that you might be decreasing if you limit and define what financial means any further than the regular normal term that we would understand it to be. Any other questions from the committee? Okay. Does anyone in the audience want to speak in favor of the bill? Anyone in the audience want to speak against the bill? Okay. All right. At this time, we're in the position to entertain, the chair is in the position to entertain a motion regarding the bill. Is there a motion regarding the bill? There is a motion. Is there a second? Okay. All those in favor? Any further discussion? All those in favor say aye. Aye. Any opposed? The bill passes. Thank you. The next item on our agenda is House Bill 912. What I'm going to do is briefly tell you the background on House Bill 912 and what it does, and then I'm going to ask Roger Martin, an attorney here in Atlanta who's worked on this, to come up and give us a more detailed explanation. In the practice of law, quite often you do something called a third-party request for production, and that's what this bill deals with. There was a settled way to handle getting documents from third parties in the lawsuit. That settled way was upset somewhat by a Supreme Court case in 2002, and what this bill tries to do is put the law back like it was before that particular court case. And let me tell you what happened. If two people sue each other and it's over someone being hurt and their medical condition is at issue, the way you got their records from a hospital once they put their medical condition at issue was to send quite often a third-party request for documents. And what you did in that situation is that you notified their attorney, the patient's attorney, of what you were doing, and they had 10 days to object in case they didn't want any documents in those records to come to you or they had a valid reason. If they did not object within the 10 days, the hospital would go ahead and give the other side the records that they had requested for. What happened, Georgia law also provides some privileges for protection of our citizens of their hospital records. If you have one of three things in your hospital records, that being mental health care background, HIV, or if you have, the other one is, Roger, help me out, what is the other one? Alcohol treatment, related treatment. If you have those three things, those are privileged records, and no one can get those records unless you allow them to do that. In Georgia, we had always assumed that when you gave the other attorney notice and they didn't object, then you were allowing someone to see your hospital records. What happened in 2002, a Supreme Court case, somebody challenged that, and the court said, indeed, no, there has to be something more than just that process I described to you by where the patient and their attorney had a chance to object. They have to affirmatively release that. And the hospital in question got hit with about $1 million verdict because they had given away some hospital records under procedure that everybody thought was the right way to do it. What this bill hopes to do is put the law back in the condition that it was before that Supreme Court case, to say that, yes, indeed, if I as an attorney send the hospital a third-party request for production and I properly serve the other side, and the other patient's attorney has a copy of the record, or the patient does, my request that is, and they don't object, then just like the law was prior to the Supreme Court case, the hospital won't be held liable for turning over those records. And that's pretty much how simple it was. When Mr. Roger Martin came to me on behalf of some of our hospitals and asked me to do this, I asked him to work with the other parties who may be in interest here, and mainly that being the Georgia Trial Lawyers Association. And they did all last year go back and forth and talk about, and what you have now is a substitute that will be in front of you, which is a compromise in some areas about some of the things that they want, and which I had no problem with. There was one particular thing that they asked for that I didn't want to open up this bill to deal with the wrongful death statute, but we'll talk about that in more detail in a second. That's a general overview. Let me ask Mr. Roger Martin to come forward now, if you would, to the witness table right here. I think your mic's on. If you would, please introduce yourself to the committee and then go ahead and take the committee through the bill, and then we'll have questions.
Thank you, Mr. Chairman and members of the committee. My name is Roger Martin. I'm an attorney with the law firm of Hall, Booth, Smith & Slover. We were first contacted about the problems that the hospitals were encountering as a result of the Kennestone decision by Gwinnett Hospital System, one of our clients. What the result of the Kennestone decision required that every time the hospital got a request for records, they were required to go through every single page of every single medical record and determine if, in fact, there was any information in there that may or may not be privileged. Sometimes this information would be as innocuous as, I tested negative for an HIV test, or it may have been a consultation that a physician may have had and said, you need to have some psychological counseling. We're going to give you some psychological medications for 30 days. The hospitals were required to go through every single page of every single medical record that they got. When, in fact, they came across something that may have been troubling or potentially, they were required to file an objection with the court. The courts were then required to hold either an in-camera review of the records or go through and hold an actual hearing and file a motion for protective order. Clearly, it became an onerous, burdensome process for it. And I have brought with me today Ms. Bonnie Richardson, who is the Associate Counsel for the Gwinnett Hospital System, as well as her medical records technician, who's in charge of her medical records department, who can tell you a little bit about the process and the problems that this was encountering. They can tell you a little more specifically the expenses that's involved, but I think you see it when you take this by every medical provider in the state having to review every single record to determine if, in fact, there is an objection that a patient has not made known to the person. What this bill does is this bill does not impact in any way on the privileges. The privileges remain as contained as determined by the Georgia legislature and the Georgia courts. What this does is it says that when a third party has no notice from a person that they have something in their records they want protected, their responsibility then shifts. They are not responsible for protecting those records. Now, the bill requires that there must be notice given to the patient, patient's lawyer. There is notice provisions within the bill. So we tailored it very narrowly. We worked very closely with GTLA, who was very helpful and worked with us on this to try and come up with a compromise. And we believe that the committee substitute that you have in front of you addresses these issues. I would ask if the committee's indulgence for just a moment to allow Bonnie Richardson and her medical records technician to come up and tell you a little bit about the procedure and what's happened under the Kennestone case.
Let's explain the situation, and then we'll allow questions from the committee about it. So come on up. And by the way, we are working off LC number 292121S. That's the committee sub that's before you. Okay. Please introduce yourself and thank you for coming today.
Thank you. I'm Bonnie Richardson, and I am the Associate General Counsel for Gwinnett Hospital System.
And I'm Donna Sanford. I'm the Director of Medical Records for the Gwinnett Hospital System.
Go ahead.
Thank you. As Roger was explaining, when my hospital gets a request for protection of documents or a subpoena for medical records, somebody in our medical records department has to flip through every single page of the patient's medical record looking for some type of privileged information. As Roger was saying, it can be as innocuous as an AIDS test that was negative. And that could be just a small line within a 3,000-page medical record or a 100-page medical record or a 10-page medical record. It varies. We do have some data information that shows that we get approximately 35 requests for production documents or subpoenas a month within the last 6 months, that each one, in response to it, we produced approximately 108 pages, which is 3,400 pages a month approximately, that somebody had to sit in the medical records department and go through each page of that medical record looking for some kind of privileged information. Before the Kennestone case, we felt that the burden was on the patient to make the objection if they had some kind of privileged information within their medical record, and they were the person that was in the best position to know that they had that kind of information. After Kennestone, the burden has been placed on the hospital to now go through and file an objection. So if we find a privileged information within a patient's medical record, either myself as in-house counsel or we hire outside counsel to file an objection, which goes to the court. The court has to look at it. They set them for hearings, so it's a time and an expense and burden on the hospital to have to respond to these RPDs or subpoenas when it's the patient who's in the best position to know that they have something privileged or confidential in their medical record. So what we asked Hall Booth to do was try to shift the burden back to the patient, which we think they successfully have done with this statute, so that the patient or their attorney can file an objection within a larger time frame. It's now 20 days instead of 10 days. So and the service will be by certified mail, return receipt requested. So it gives notice to them that their medical records are being sought. It gives them an opportunity to file the objection, but takes the burden off the hospital from having to look for each and every page in the medical record. If the hospital does produce it, it doesn't in any way abrogate the patient's privilege. They can still object. It does not mean their medical record would be introduced into evidence, that they've waived their privilege in any way. It just means that the hospital would be immune from civil or criminal liability.
Thank you.
Donna's done some research as far as actually what this has cost Gwinnett Hospital over the period of, you want to go ahead and share that information if you would.
Sure. I hesitate to touch that. Over the past 6 months in my associate's time, that is actually a credentialed health record professional sitting looking through these records, of the average of 35 a month, or it's 178 requests for production that we've received over the past 6 months. At a minimum, it takes her 2 hours to go through any medical record page by page looking for that privileged information. The woman that's in this position now makes about $15 an hour, and so it's cost the hospital system just in salary to look at those pages $5,400 to do that. As far as time goes for those 178 requests, that's 356 hours of her time in a 6-month period, or roughly 9 weeks during a six-month period of time, just to flip through those pages, looking to see if there is any privileged information in there. If we do have anything that requires attention by our legal counsel, then that's another minimum amount of time on the legal department's part as well. It may be as simple as answering some questions and getting us answers back, or it may be as complicated, of course, as filing that objection.
And we file approximately 11 objections a month from my office within the last 6 months, the data for the last 6 months. And we're one hospital, obviously. So every hospital is faced with the same issues that we are.
And let me summarize it this way to the members of the committee, and then we'll go ahead and allow you to ask questions. We constantly look for efficiency in government and the way we do things. And the idea here is that we had a system prior to 2002 that by most people's standard was pretty efficient. In other words, the person who knows best whether there's anything in the records that they might not want someone else to know is the person whose records they are, rather than shifting that burden to the hospital who are not familiar with the records and have to hire someone, a professional of a high enough standard, to spend the time to go through there and figure out what I already may know about my records. So all we're going to do with this bill is turn the law back to the same way it was before 2002, which a system that worked for a long time very well in most people's opinion, and also save our healthcare institutions their dollars. And like I said, we have worked with all parties that we thought would be involved with this. Having said that, let me stop and see if there are any questions by committee members regarding this legislation for any of our witnesses. Chairman O'Neill.
Of the 19 objections, or the objections that you filed just generally, do you have to specify the information that you're objecting to? I mean, hence revealing?
Actually, under HIPAA, you can't do that, which is the federal protection for the medical records. So we just file objections that say that the record may contain confidential or privileged information. that we are producing a redacted copy of the record to the other side, and then the other side can file a motion to compel if they want to get a full copy of the record from the hospital. We also send an authorization and recommend that they talk to the opposing counsel, because with an authorization, of course, we can produce a complete copy of the record. So we do not specify which, we used to prior to HIPAA, but after the enactment of HIPAA, we do not
In your
anymore.
estimation, how many extra people that wouldn't otherwise be exposed to potentially privileged information or confidential information because of this obligation that you have are now, because of, I guess, due to this ruling in '02, are now trampling through people's records?
I'm sorry, I don't think I understood
I
it.
know that the people in the hospital,
Yes, sir.
on a need-to-know basis, can use these records. I don't imagine a record technician is going to be treating the patient. So, I mean, that's one
That's
person
correct.
that, if I had AIDS or something, by the way, I don't, would know that. And I don't want anybody to know that, even a technician. But now, because of the status of the law, people that have no other need to know about my privileged things are having to know that, right? I mean, is that
Yes, sir,
one
including
of the
my
laws?
office. Even as the attorney for the hospital, they obviously have to contact me and let me know that there's something that's in the record that wouldn't otherwise be. And then there's a public court filing that does say that the record may contain confidential or privileged information. So it wouldn't specify what, but it would alert somebody that there may be something in the record.
But you as an attorney, too, would know, and
Yes.
possibly even your staff people in your
That's
office
correct.
would know I'm a worthless drunk and all
That
that
is-
stuff that wouldn't know.
And when she's on vacation, my law firm has to take over, and there's any number of people who would see it then.
And many times the technician has questions for the director of medical records, so the director of medical records would know within their department. And then there's assistant director of medical records who also may get questions from a patient's medical record. So it's really a number of people who, as you pointed out, will now have an opportunity to know that there's something in somebody's medical record that wouldn't otherwise have a need to know.
Last question, Mr. Chairman, if you mind. This probably would expand to doctor's offices as
Yes.
well, and every other caregiver organization that's out there that maintains what potentially could be privileged information. Is that correct?
That is correct, yes.
So your point, Representative O'Neill, is something I hadn't even thought about, and that is that a reputable person like yourself, very well known, and people might want to know about you if you ever had a lawsuit, and I could ramble through the public filings, and if I found an objection by a hospital, I could say, aha, there are 3 things that have happened in his past at least: HIV, alcohol treatment, or mental health problems. Okay, let's see here. Always looking out for you. Let's see, Representative Houston.
Thank you. I have no idea what would be in my medical records. Do you ever write things? Do the hospital or doctors put things in people's medical records that the patient's not aware of?
I'm sure that they do. I mean, they write whatever they feel they need to write in order to support their diagnosis or their treatment. So
Do people usually read their medical records to know what's in them?
many people do, some people don't. I mean, I guess I don't really know.
How many people request their medical records to read just to, do you
I
have
couldn't
to
answer
request,
that
do you have
question.
people just to know what's in their medical records? Does your medical
We don't have any
records say
data
that?
information on whether somebody would just request their own
So
medical
most
records.
people really don't know what's in their medical records. Would you say that?
I believe I think they do primarily know what's in their medical records. The physicians in our hospital, the nursing staff, the people that treat the patient, have an obligation to keep that patient informed as to what's going on with them during the course of their hospitalization. They may not know every exact word in that medical record, but they certainly know what the doctor is thinking, the kinds of treatment and tests they're having, the reason why they think that's being
So
done.
it would be a good thing, though, for a person to review their medical records before they have them released.
If they choose to, yes. I mean, obviously you wouldn't have an AIDS test without, we don't test people without telling you
Right,
what
I
you're
know
getting
that.
tested
Yeah.
for. So you don't get treatment for injuries or diagnosis or illnesses that you're not told that you would get treatment for. So the kinds of information we're talking about, in other words, if you have received some kind of psychiatric treatment or mental health treatment and you're prescribed a medication, obviously you know that you got your medication and you know what you got it for. If you got an AIDS or HIV test, you would know that you got that done. Or if you have substance abuse problem and you were sent for treatment, you would know that you had been sent for treatment for that problem.
If I may, the bill doesn't, the committee substitute doesn't really change a patient's duty or obligation to know what's in their medical records. Yeah, they should. I mean, I think we all should. Do we? Maybe we're not all good patients, but, you know, the bill basically is going to give the patient the 20 days notice now, which current law is now 10, so we're giving them more time. If you perceive there may be something in your medical record, you know, maybe that doc said, you know, when I was, you know, he was saying some things I didn't like, I need to see my records. You now will get 20 days to do it, but you can also say, I object to the release of your medical records, and you then are, you're the captain of your own ship.
Thank you.
Representative Tumlin, you have a question? Any other questions from committee members to the witnesses we have right now? Thank you all very much. I want you to hold on because quite often questions pop up as we go through this, but I do want to give anybody else in the audience an opportunity to speak in favor or opposed to the bill. Is anybody else who would like to speak regarding the bill? Bill? Come on up, Bill. Please introduce yourself to the committee, and thank you for coming today.
Thank you, Mr. Chairman, members of the committee. I'm Bill Clark on behalf of the Georgia Trial Lawyers Association. And I really just want to stand up and support this bill and say thank you first to the chairman and then to the hospitals that Mr. Martin represents and the Georgia Hospital Association for approaching us with what we immediately saw as a very legitimate concern that hospitals and other healthcare providers are being put through as a result of the Kennestone decision. I'll tell you that this bill, in our view, appropriately balances the privacy interests of the patient that Representative Houston so correctly points out is a concern, but also restores the efficiency that you've spoken of here so that healthcare providers can handle this volume of requests that they get typically from lawyers representing a defendant in a personal injury or other types of litigation. So we support the bill. We believe it's an appropriate balance of all the interests. And again, thank you, Mr. Chairman, for letting us work with you and with the others on the bill. And I'm glad to answer any questions if there are any.
And Bill, I'll just tell you, we appreciate you working with us on it, and I would note that the one change that we made at your request was that we used to be, if we put the law back like it was, you had 10 days to make that objection. We've changed the law now where we give you 10 more days, twice the amount of time, 20 days, to make the objection if you don't want anybody to see your medical records at that point.
One of the points in the Kennestone case was the inadequacy of the time to object that a patient would have, and so we felt like that was an appropriate way to respond to the concern raised by the court in that decision so that this law wouldn't be subject to the same type of challenge that the Kennestone case, or the same problem that the Kennestone decision presented the prior law.
I spoke with several litigators about this issue of a little more time, and most of them, well, all of them, everybody that I talked to, which was several people, said that, you know, as a lawsuit goes, which can go on for 2, 3, 4 years sometimes, 10 days versus 20 days is not a big problem either way, but it does significantly doubles the time that a patient has if they want to make an objection or their lawyer wants to make an objection. So at this time, are there any questions from committee members for Mr. Clark? Representative Tumlin.
Is this 20 days of when the request, or is it 20 days when service is perfected?
I believe the phrase is 20 days from when service is made. I don't have the bill in front of me, but the line that's underlined from service.
In other words, when the day they perfect laying it on you, then that's when the clock starts counting.
That's my understanding.
The mailbox rule would probably give 3 more days in there, I think, if you did it by mail.
Line 19 doesn't have that same language. If no objection filed within 20 days of request.
So you would say it should say within 20 days of service of the request.
Yeah, make line 13, line 19.
That'd be fine with us. Roger, does that make sense?
We're okay with that.
So that would be on line 19. It would read, and I'll start on line 18 with that sentence. If no objection is filed within 20 days of insert service of the request. That would make it just like line 13. At the appropriate time, I'll recognize Mr. Tumlin for that amendment. Any questions of Mr. Clark? Representative Knox, will you press your light there and I'll turn your mic on? Whatever one you press, I can turn on for you. There you go.
I apologize for being late. I was in another committee meeting, Mr. Chairman, but and I may have missed on this. Will this also cover those entities that are providing medical records on a contract basis or that sort of thing? I've noticed a lot of medical providers don't fool with their records at all. They want to have a contractor that makes the copies and does all that sort of stuff. They benefit from the protection of this as well as the who would be otherwise be providing records, the entity itself, third-party provider, third-party.
I believe we've used the phrase intentionally healthcare providers, and I think the case law suggests that those who would provide records are agents of the healthcare provider. Whether that would mean they would be, whether this bill would afford them the same immunity or not, that's a good question. I don't have a complete answer for you.
I was trying to find Chairman Knox in the bill where that distinction would be made. Was there a particular place in there that you were thinking that?
No, I just don't.
Line 14 through 16.
As I read it, I'm not sure that there's any indication that those kind of providers would be afforded the same protection. And I think that's pretty common these days, and I'm not sure whether it applies so much in the hospital setting or not. But I think it does some hospitals, and larger hospitals that have their own staff and so on and so forth. But it seems to be a good bit of that is done by somebody that's not even a third party, maybe under the scenario, and they probably want to have. I don't know if that's going to be a problem or not.
Well, if you look on line 23, for example, it's on page 2. It says when the non-party to whom the discovery request is made. Non-party would describe anybody who is appropriate custodian of records, I believe. I think that's probably your answer. Anybody who's a proper custodial has custodial authority over records would be included in a non-party. Mr. Chairman, did you have any other questions? Okay. Any other questions from members of the committee for Mr. Clark? Any other questions? Okay.
Thank you, Mr. Chairman.
Thank you, Mr. Clark. Anybody else who wanted to speak regarding the bill? Okay. Please come on up and introduce yourself to the committee, and thank you for coming today.
Thank you. Mr. Chairman, members of the committee, my name is Temple Sellers, and I'm the attorney for the Georgia Hospital Association. And much like Mr. Clark, I want to thank you, Chairman Fleming, for your leadership in sponsoring this legislation, and to the members of the committee for an opportunity to speak in support of it. We, too, agree with Mr. Clark that this bill really does appropriately balance what are legitimate competing interests. We're grateful to Bill and the members of the Georgia Trial Lawyers Association for working with us. I think the bill appropriately balances those interests by providing even more protection to ensure that the patient and the patient's attorney is going to receive the information. You note that the information has to be sent by certified mail or statutory overnight delivery. And it also provides, as has been noted previously, more time for the patient or their attorney to object to the release of the information. So those are some added protections to ensure that the notice is actually received and that there's more time to object if you do have a concern about the release of your information. It simply provides immunity for hospitals and other facilities and practitioners if they should release information that happens to contain privileged information where there was no objection. And as I think Bonnie noted previously, it doesn't in any way affect the privilege. So if there is a release of information that does contain privileged information, the patient who is probably a party to a lawsuit would be able to object to the use of that information against them in whatever the underlying lawsuit is. So, again, we appreciate your leadership in sponsoring this legislation, and thank you for an opportunity to speak in support of it.
Any questions for the witness from the committee? Thank you, ma'am.
Thank you.
Anybody else who wants to speak regarding the bill today? All right. At this time, I believe what we will do, is there any further discussion from the committee? Let's put the bill, let's accept a motion at this time, and then we'll put it be in a position where we'll accept amendments. Is there a motion regarding the substitute? There is a motion. Is there a second? There's a second. Are there any amendments? Representative Tumlin.
Mr. Chair, I'd like to propose on page 2, line 19, after the word days, add of service.
Actually, after the word of, we want service of, should be within 20 days of service of.
Yeah, days of, after days of service, then of the request.
Okay, gotcha. So this is the way it would read, beginning on line 18 with that first sentence there. If no objection is filed within 20 days of service of the request. Okay. Is there any discussion regarding the proposed amendment? All those in favor say aye. Aye. Any opposed? The amendment is carried. Now we're back to the question on the bill itself. Any further discussion before we vote? All those in favor of the committee substitute to House Bill 912 as amended, please say aye. Aye. Any opposed? Ladies and gentlemen, thank you for your time today.